Thank you very much to all of you for being here. Let me introduce myself. I'm Delphine Agoguet. I am the coordinator of this Legivoc project. This project was initiated and implemented by the European and International Affairs Department of the Ministry of Justice of France. I'd like to introduce Hughes-Jehan Vibert, who's the head of this project, Legivoc. Legivoc is a European project. It was supported by the European Commission, which funded the project with our partners that co-funded the project. We have as co-funders the Luxembourgish Ministry of Justice with Viviane Faber. The Finnish Ministry of Justice could unfortunately not join us. Mr. Akinen could not join us. We have the Spanish Ministry of Justice that sent as a representative Mrs. Aranxa Arsuaga Lecuona, who works with the General Counsel of the Judiciary in Madrid. We also have with us Jana Hofmanova. She's in the room and she represents the Czech Ministry of Justice. We also hope to have the Office of Publication following us on streaming today. We have a number of speakers. Mr. Agnoloni, representing Italy here, who's also a member of the steering committee of Legivoc, the project. We also have the honour of having Mr. Mazet with us. He will take the floor later on. He's an expert in legal terminology and information technology. We have also Barbara Due on my left, representing the Court of Justice, Mr. Spyros, representing the European Commission, and in particular its translation department. He will be talking about automatic translation today, and our interpreter is in the booth. Mrs. Vandenplas is with you as well. She will be working alone on this conference, so we will have to take breaks regularly. As I said, this is a meeting that will last 3 hours, 3 hours that will be dedicated to introducing the project. Now, we had different possibilities. Either organize a project that would be of interest for, or meeting rather, that would be of interest only for our steering committee, but we chose to open the debate. And we could, of course, always exchange in writing afterwards. But this conference is open to all because, as I said, it can be followed on live streaming. Indeed, the Legivoc project is a project of, well, IT internet-based vocabulary. So it was, of course, quite logical to be in contact with all existing networks interested by legal vocabulary. And you can also send your questions via Twitter. You should normally see on your screen the Twitter address appearing. Now, the red line of this meeting will be, of course, the presentation of the Legivoc project. We will be discussing a number of things. We will be talking about, well, legal information technology, legal internet, vocabulary, languages, thesaurus, automatic translation, alignment of the legal concepts, and all these are the keywords of our project. There's another keyword in this project, or a series of them. It is the issue of access to the law. Indeed, the objective of Legivoc is to create a terminology database that will include the legal vocabularies of the member states. Each vocabulary, as you will see, will be translated in all official languages of the EU, and the project also offers a method to align the different national concepts. So the objective, the point of this project, is to facilitate the search for information, to facilitate access to the laws of the member state. Quite recently, a report was issued by the presidency of the Council to the ILO group. It was on the 3rd of December, and it really focuses on this issue of access to the law. It is a very practical document, and it sort of takes stock of the situation with regards to access to national laws as well as legislations of third countries. This report reminds of the difficulty related to the language issue and the importance of proper translation in the existing vocabularies. Now, the Legivoc project is mentioned as an ambitious project, which is precisely in the context of this objective of the EU to promote access to the law in a multilingual environment. I'd like to give the floor to Hughes-Jehan Vibert right away, and he will introduce the project and tell you where we stand at the moment. I'm sorry, I cannot hear Mr. Vibert. Well, thank you very much indeed, Delphine. As mentioned by Delphine, we had foreseen a meeting at the steering committee, but we will have something different now. We will not have a round table as we were used to, because we do address an audience which is not sitting in the room. So our audience is online. Even if we have a few speakers in the room, we have representatives from the Czech Republic and Hungary in the room. For those of you who are online, the access is granted through legivoc.eu, and you have hashtag Legivoc on Twitter. The idea is to be online and international. Are present and attend this meeting people in the US, in Cincinnati, Chicago, as well as Latin America, Mexico, as well as Uruguay. And we also hope to have viewers in Australia and Lebanon with the Arab Center for Legal and Judicial Research, as well as people from the European Union. So with this small meeting, we can indeed give a very international side to our project. So thank you very much indeed for being with us. As mentioned by Delphine, 6 states supported this project and participated in the project. Thank you very much to them, because the objective of this meeting is also to listen to them and have their opinion on the project and the way we conducted the project together. 6 member states participated. Legivoc is a database with legal terminology. It's a multilingual database, and it is an aligned database. In other words, it is aligned between the different member states. We have different speakers foreseen who are specialized in certain areas which have been included in Legivoc. Indeed, we have decided to include national vocabularies to align the different legal concepts in the law of the member states. We have experts in language issues as well, automatic translation. This will be discussed as well during our meeting. The European context first. We have 24 official languages in the European Union. These 24 languages are all official as regards European law. There is one project which is a good symbol of this ambition. It is the NLEX project. This is a common gateway to national law. So there's one single portal giving you access to all the information systems in the member states. So this is a description of the European context. Any French speaker, any English speaker, or any other citizen of the world could search for information on Greek law, for instance. The difficulty is a practical one. Well, for instance, you need to have a right keyboard, and you need to know Greek, of course, to understand what appears on your screen. And this is quite a difficulty when it comes to access to law. There's another element of the context. Indeed, we're dealing with a topic which is limited to the European area, but talking about the law, it's not simply a European law. You have indeed a tool allows you to index European legal information. It is Eurovoc, which is a multilingual thesaurus with all the languages of the European Union. This thesaurus offers classified information, vocabularies, but once again, this is a thesaurus which is very specific to the European Union. It's just for the European legal information. Let me give you a concrete example that we've shown many times within our steering committee, but it's also part of our introduction here to explain the context. Imagine that you are a British citizen and that you look for information on NLEX, which is a common portal allowing you to access different areas, different domain of legal information. Let me go back a few slides. In that context, let's say that the person coming from a common law system will look for information on tort law, which is a concept very specific to the common law. So using the NLEX portal, he will use Eurovoc, the thesaurus multilingual Eurovoc. This allows for a better understanding of concepts through languages, through the different languages. Now, this may be an exception, but Eurovoc does not give you the possibility to find any results on the issue of tort. So this British citizen, or at least this British law citizen, knows maybe that he's from a common law system and that he's searching for information in a Roman law system. Now maybe he's got mixed origins and he's partly Scottish, so he knows that it is an issue of responsibility. Maybe he will use the term delictual responsibility. So he will indeed type, well, responsibility, delictual responsibility. He might find liability, which is a concept present on Eurovoc, and he might find something related to delictual responsibility, or maybe he might find, well, concepts related to civil law that you can find in Roman law systems, at least in France. So civil responsibility, civil liability, that's one thing. This term is translated in Eurovoc, and it's, well, he will come up with a number of results, and it's up to the viewer to interpret them. Somebody who's British, from common law system, from the UK, who looks for information in a Roman law system, needs to have a proper knowledge of what he's exactly looking for, and he will have to have so many intermediaries that it may no longer be very useful. It will be quite difficult to interpret the results because the official languages of France being French, of course, all the descriptive concepts will be in French, so it's quite difficult indeed to find the information. Now, a thesaurus is quite a practical tool when it comes to indexing. In fact, the Belgian Senate uses Eurovoc, the thesaurus. And what the Belgian Senate says is that, well, they use Eurovoc because of its intrinsic qualities, because it is, of course, largely influenced by EU law. There is a major influence of EU law on national laws, but they also use Eurovoc because there is no other solution. In other words, there is no multilingual thesaurus that could be used, and it was necessary for the Belgian Senate to use Eurovoc, but in a Belgian context. In other words, adding terms that are specific to the Belgian law and culture and specific to its complex society. So indeed we are in Brussels, so it's a perfect position to talk about this. So the law is one of a culture. It is not the only element. Language is another one, history as well. But it is true that the law is part of the elements that compose a culture. The European Union has one motto. It is "In diversity we're united," and indeed we have 28 laws represented on this slide with a number of specificities. I rapidly described them. We have a common law system in Ireland and the UK. We have Cyprus and Malta, which have legal systems, mixed legal systems, civil law and common law, and we have a large majority of European countries with civil law systems. We have local specificities. In Scotland, we have a mixed system, civil law and common law. And there are other specificities. In fact, in the UK, we have 3 systems in England and Wales, Northern Ireland and Scotland. And we also have the Länder in Germany. This is the example, and this is the case in Austria as well. The objective of Legivoc is to connect all these concepts, all these legal information to come up with relevant results. So the idea is to make a connection between the legal characteristics of each one of the member states of the EU. Legivoc is presented here at the heart of everything, but of course we're talking about law only. Legivoc is a tool, and its ambition is to be used by all existing platforms where these cross-border or international issues are discussed. This is the example of e-codex, for instance. We have a number of platforms that connect different legal systems, and Legivoc can be a tool used at the heart of all transnational legal information systems. The objective of Legivoc is also to help citizens when they search for information. This is the point of our work. Now, ignorance of the law is no excuse, and this is precisely what we're talking about here. Now, you see on the screen different languages than the ones we have in the EU, but we will come back to this in a minute. This was a very brief and quick introduction for our audience online. This is the third meeting of the steering committee, and we have already presented a three-part plan. The first one was the search for legal vocabularies from each member state, then the alignment of national vocabularies, and finally the adoption of common technical standards. Searching for legal vocabularies. This was an issue that had been identified at the first meeting of our steering committee. Indeed, there is a wide diversity of formats transmitted by the member states, and we asked every member state of the EU to provide the legal vocabularies they might have available so we could process them and integrate them in Legivoc. What happened is that we received information, a great deal of it for that matter, but of course it came in different formats. First, I'm talking about physical formats. I mean, we had PDF, text, doc, Word formats, XML, and the structuring of these files was different from one system to another, and we will have a few examples of that later on. What you have here in front of you is the Belgian legal thesaurus, which is used by the Supreme Courts in Belgium. There are 3 official languages in Belgium. You see on the left column an abstract in French, and you see on the right-hand side an abstract in Dutch. What you have here is a text which we did not use in the end. It's a text that was sent to us by the Bundestag in Germany, and it was available in PDF format. But after all, parliamentary law was less interesting for this project, so we chose labour law. This is the vocabulary as provided by Finland, member of the steering committee. By the way, Finland apologized for not being present today. And we do welcome them because we know that they are with us. We thank Aki and Lina for their cooperation. They are with us online. Thank you very much indeed to Finland for providing very rich documents in Finnish, in Swedish and in other languages as well. Malta provided a document in 2 official languages, Maltese and English. These are the Netherlands, a document which is structured in XML this time. Luxembourg provided a PDF document, and we have a problem with PDF documents. The UK provided a document in a different format, and this is once again something related to the XML format, but it's organized differently. So what is important is also to understand the way these files are organized. Sweden also provided a PDF file, so we did not have one problem, but rather 28, because there were 28 different situations. We did not obtain 28 different formats. Fortunately, only 18 legal vocabularies were provided. For the others, for the ones who are not members of the EU, you should know that there are 28 member states in the European Union, 18 member states. did provide legal vocabularies because these legal vocabularies were already set up. Others decided to set up a legal thesaurus to put them available. This is a case of Croatia and Italy, I think, that will develop a thesaurus very soon that will be introduced later on in Legivoc. And so we have 10 expected legal vocabularies for the future. Now, given our experience of such projects, obtaining 18 vocabularies in such little time was a really big satisfaction. We thank the Member States for participating in the construction of this project. I think all the members of the steering committee do agree on this point. I was just introducing an abstract from the project because it was difficult to show you the 18 vocabularies, but of course we'll come back to the Spanish example later on. We had difficulties with some of the vocabularies because, as I said, they were available in PDF format. We still have to integrate 14 legal vocabularies in Legivoc, which means half the member states of the EU are represented, sometimes in a very exhaustive way, sometimes in an incomplete way, because content is limited. It's the case for the UK vocabulary, for instance, but of course we're hopeful for the future. For Germany, we have labor law vocabulary, but it's a very exhaustive work that has been provided by a legal publisher, and it is in fact publicly available, so we could use it quite broadly. I show you some of the icons that illustrate the fact that sources are diverse for these vocabularies. We have documents from the executive, usually the Ministry of Justice, the legislative, the judiciary, Supreme Courts, for instance, in the different member states. We have other sources as well, so the Parliament, as we said before, the judiciary, universities as well. Some bar associations contributed, as well as legal libraries. We added Eurovoc, because Eurovoc is already available in the European system, and there's a great influence of European law in the member states' law, quite naturally, and Eurovoc can naturally be integrated in Legivoc, which we did. Now, this brings us to appreciating this issue of legal vocabularies, and we will have two approaches. A rather technical approach, and if I understood well, there will be a documentary approach as well. So we will start with Aranxa, Arsuaga, Lecuona, who will talk about the Tesoro vocabulary. So this is the Spanish legal vocabulary.
Thank you. It's okay like this, it's okay. My name is Aranxa Arsuaga, and I work in the Documentary Center for the Judiciary. That is a technical body of Spanish Council, which functions are compilation, processing, dissemination, ordering, distribution, and publication of legal information. So it's for that in order to carry out our mission, we collect for every court the sentences, and we transform all different formats that we received in one XML format. And we publish them in several websites. A public website with all the documents, and a private one to the magistrates or judges, publishers, lawyers, and others, with some added values like a thesaurus to find the information easier. In nowadays, we have 5 million of sentences. So we realized that we had a lot of documents, and we decided to create a thesaurus. We decided it was necessary to classify all the documents in order to to make easier and more efficient to find information for the users, for the judges and magistrates. So to create the thesauros, we used source of information like sentences, of course, and specialized laws and codes, civil code, criminal code, Spanish laws. But not all of them, the specialized one, not all of them. And the selection of the terms were based on the frequency of occurrence of them within sentences. And we also took into account the international standards for monolingual thesauros, ISO, EU, and E, or so on. Eventually, we created 6 thesauros, each for one jurisdiction: civil, criminal, labor, litigious, military, and constitutional. And they are structured according to 3 main relationships: equivalence, hierarchy, and associative. Our thesauros is alive, is changing, and we work with some judges and magistrates who collaborate with us doing the analysis of the sentences, and they propose us new terms or synonym terms or modify some terms, and also is changing the thesauros because of the laws. They change the laws changes, so the law changed, so the thesauros had to change. For instance, in Spain was obligatory before the service military, and now it's not. So it's changed all the time. So we review the proposal sent by the judges and magistrates and update the thesauros to new versions. When we update to a new version, we have to modify also the sentences classified by the thesauros, because some terms could to change. And we have to republish the new thesauros and also the sentences reclassified. And how we use the thesauros? We use the thesauros, as I said, in a private site for the analyst. They used to search the terms, navigating versus the thesauros, on the thesauros, and electing some terms to add it to the sentences. And also, in a public website, in the public website, we offer in ITTIG Cloud direct access to sentences that are classified in some matters of common interest. And in a private site for the judges and magistrates, they could search by a thesauros, navigating from the thesauros, or just writing any term. We also have other collaboration sites. I don't know if we know, but there is Iberius. It's a Ibero-American network of documentary center, and we participate there as coordinator in a project called Portal of Legal Knowledge. Spain did a test, create a website only indexing some sentences in criminal matters, indexing also the criminal code, and in the various group, we did a list of descriptors with equivalence in criminal matters, but not all criminal matters, criminal offences not all criminal matters, because there were a lot. And we put in this website, test website, to do the search of the sentences with this information. It wasn't a thesaurus, only a list of descriptors of terms. And now we are participating also in Legivoc, and that's it. It's okay. So thank you for your attention.
We found it very interesting to discover this Spanish thesaurus, because we consider that this is really an example. It is a live instrument and it is constantly maintained. There are different interfaces, collaboration interfaces, and it is something that is addressed to experts. It was very interesting to recognize and to see that. Now, we would like to give the floor to Tommaso Agnoloni to introduce the Italian experience of the Institute of Legal Information Theory and Techniques.
We'll give a brief overview on a report on the activities that we have carried on in Italy for the construction of the Italian legal vocabulary. I am Tommaso Agnoloni, and I'm a researcher at the Institute of Legal Information Theory and Techniques, which is part of the Italian National Research Council. And as a subject that we work on, we deal with law and ICT, legal information standards, legal semantic web, legal multilingual web, and natural language processing of legal texts. And that's the reason why we joined the Legivoc steering committee. Here I will give a brief overview of what we have done so far for the selection of the candidate legal vocabulary to be brought as input to Legivoc, and the work that we have done on the selected vocabulary in terms of format conversion, supporting platform, publishing and licensing strategy, and what are our plans to improve the Italian national vocabulary. First of all, we selected the Italian representative for Legivoc, following the criteria of representativeness of the selected vocabulary in terms of the subjects that it covers. And also the focus of the selected vocabulary in terms of the subject that is more focused on legislation or on judicial subjects, for example. Then its actual availability in terms of data, in terms of format, and in terms of license, and the fact that the vocabulary is actively maintained, and another important issue is the fact that the vocabulary is effectively used, which means that it's connected to annotated documents that are annotated with respect to the subjects of the vocabulary. So the candidates that we selected are from institutions, so institutional vocabularies. We analyzed the vocabulary of the Supreme Court of Cassation, that is more focused on judicial subjects. Teseo, which is the vocabulary of the Italian Senate, so it's used for the annotation of legislative bills. The Italian version of Eurovoc, that in spite of the fact that it's more focused on European legislation, is very used in Italy in institution at the Chamber of Deputies, and also for the official publication Mazet. And then we considered also vocabulary, dodgy vocabulary that we constructed and maintained at our institute for the annotation of legal doctrine. So after this analysis phase, Teseo, which is the vocabulary of the Italian Senate, have been selected in agreement with the Italian Senate and the Ministry of Justice, Teseo dates back to the 1992, but it actually originated in the list of subject descriptors for the classification of parliamentary acts, and it's rooted in the terminology that was in use in parliamentary paper indexes since 1848. Teseo is structured as a thesaurus. It's a mono-hierarchical thesaurus, so the single class of most frequent use is used as the head of the tree. It contains relations of broader and narrower terms and related terms, and also use for lexical variants of a concept. And it is based on the universal classification. It's connected with the CJUE, the universal classification, and it extends it. So one important thing in terms of its content is that it's not specialized in a particular field, but it extends to the whole social, legal, scientific reality which is object of legislative norms. So it's not only, at least, a legal vocabulary, but it's more universal classification. It is structured in 45 areas where descriptors are grouped, which are the top terms of the vocabulary. They have different level of granularity, and it reflects the interest of the Parliament, because it evolves with the activity of the Parliament. And one important thing is that it's regularly maintained and periodically updated. Usually it's updated at the end of every legislature. The current version contains more than 3,000 concepts and almost 2,000 relations. And this is how Teseo, when we started, was available. It's available from the website of the Senate, and this is its structuring in top terms, and its hierarchy, and its alphabetical view. Another important aspect, as I said, that Teseo is actually in use for the subject annotation of bills inside the Senate, and the annotation is both at the level of the whole act, of both of parliamentary bills, acts and dossier, but also the annotation is available at the level of the single articles of the bill. So it's quite a very big important source of data, the connection among between the text and the subjects that can be reused, and this is one of the reasons why we chose this. And what we have done is conversion into the SCOS format. Maybe this will be explained later. But anyway, what is important for the reuse and for the publication on the web in interoperable and distributed way is the use of a common format with a shared semantic, and this allows the single vocabularies to be connected and to be connected in terms of the semantic and their descriptors. The SCOS is a W3C recommendation. It's a very simple knowledge organization system, which is centered around the notion of concept. Each concept is related with other concepts, with the relations of broader, narrower, and related relations. And each concept can have one or more label associated to it, which are their lexical expression of the concept, and specifically the preferred lexical expression, and all the available alternative expressions. what we have done is to make available the thesaurus that we selected, the Teseo, into SCOS, and to do this we developed some software for the lossless conversion from the available text-based data dump, which is available here, which is something that we started from, into the representation into SCOS. And especially the definition of the namespace for the publication on the web of the vocabulary and the specific URIs, the identifiers to associate to each descriptor. This activity intersected with what is being done in the Italian Senate since some year, which is an openness strategy, an open data strategy for the publication of every data that the Italian Senate produces into an open data portal. These are released with open format, specifically in RDF, and with an open license, the Creative Commons 3.0, the same has been done and will be done for the vocabulary expressed in SCOS. What is important, in fact, is that SCOS, the SCOS format, which is expressed in RDF, is fully linked open data compliant. So this means that we put our small piece to the linked open data cloud, and the data that are published are available for the interconnection and the reuse to other, and especially for the interconnection to all the other vocabularies and the alignment to all the other vocabularies that will be published in Europe. To say that is, for example, the availability of the open data in the Italian Senate, for example, allows for the creation of very simple, this is just an example of a very simple exercise of reuse of the open data of the Senate, where with a simple query in Sparkle, which is the query language for the semantic web, to the data published by the Senate, you can have, for example, the representation of the workload of the annotation of the articles of the bills that have been presented in the Parliament during a period of time, for example. What we are doing and we'll do during next year is the development and testing of a platform, a web platform for the maintenance of the vocabulary, of the Teseo vocabulary directly into SCOS, and to do this we will probably reuse the Workbench platform, which have been originally developed by FAO, the United Nations Organization for Food and Agriculture, and we tested, and we will probably reuse this platform for the whole management of the evolution and maintenance of the vocabulary. And what we are going to do during next year is to augment the vocabulary that we published with mappings obtained by semi-automatic semantic alignment with other national vocabulary and to the Italian version of Eurovoc, and indirectly we will realign with the vocabulary that have been published and have been made available with the Legivoc project. We will also do some extension to cover jurisprudential subjects, which is one of the subjects that we are working on, and also for thesaurus management, as I said, and also for the support of automated document indexing based on the connection of the descriptor of the thesaurus with the legal text that are connected. And that's all for now. Thank you.
Thank you very much indeed, Tommaso. It was very interesting to see how ITTIG has been capable of helping structured vocabularies evolve in the framework of the semantic web. So it was really interesting to discover your methods. Thank you very much to all for your presentations. So the idea was to look at the way a vocabulary could be developed, and especially the standards that were looked at in view of its publication. The Legivoc project was supported by a developer. It is in fact from the École des Mines in Paris. It's Mr. Benoît Pain and Mr. Benoît Jouvelot who contributed to the project. Now, the advantage in being supported by a research centre is that we had a very constructive way of looking at the project. We did discuss this with the steering committee, but we were also supported by this research centre, and it had a great influence on the project, including by correcting some mistakes we may have made at the beginning with regards to the content management system we wanted to use for the Legivoc project. So we would like to pay tribute to their contribution here, because they did a remarkable job, very simply. And these are the words needed to qualify their work. Legivoc aims at being at the heart of the different legal information systems in the different member states. We have 15 vocabularies available in different formats, and we had to process them into one single format to be able to integrate them in the same system. Well, we are talking about quantity and quality. We have 81,725 terms, to be precise, and yet this is not totally precise, because by the end of the year we will integrate a complement to the the Tesoro system. We have 8,000 concepts so far, I think, but we will also integrate the Croatian thesaurus, available in Croatian, but also English, German and French. So 81,725 terms at the moment. Now, the difficulty was, of course, to choose a content management system. Tommaso talked about Agoguet, developed by the FAO. We thought we would use Tematres, which associated two important elements. First, a formatting dimension, but also a visualization dimension, because we had to make the project visible and accessible, just like Eurovoc is. And this is the website you can look at simply via Google. I'm presenting here the work done by the École des Mines in the project. What they have achieved is, rather than using content management systems that pre-existed, given the project, given the mass of information available on the website, all member states of the EU, and we will discuss this at length, all the official languages of the EU, that was a great deal of information, and none of the two existing systems was capable of taking in so many legal systems and so many languages. It was therefore necessary to adapt the system to or the content management system to one that could integrate all the content we want to integrate. So it's indeed a new system that was developed by the École des Mines, and it is specifically dedicated to Legivoc. Now, I will show you a little video, which is very simple. This was presented and prepared by the École des Mines. You have here the possibility to insert a new vocabulary. You can create it by adding FR, which is the code. So the object was created. The properties of the vocabulary is that it's French vocabulary. The official language is French, so the code is FR. Is associated to that country one official language. It is the case in some member states that we have several languages. It is the case in Belgium, for instance, with 3 languages, but here we have only one national language. So we have the official language French, and by way of information we have English as well. For example, this is aeronautics. Definition can be added on this content management system, and another important element is that you can add examples. I will stop here simply to mention the ELI and UCLI standards for those who are Europeans in the room. These are standards to index texts, laws, but also case law. So UCLI and ELI, these are standards used in all member states of the EU. So in that box we can add the ELI or the UCLI element. This can be added at the end. So I'm here closing the parentheses. So one definition can be added, should that definition be available. And we will continue to feed documents and terms into the project. So we have the concept of airplane, aircraft, available in French and in English. We have a definition of what the aircraft is, and we then have a connection between the aeronautics concept previously mentioned and the broader concept aircraft. You simply slide and drop the term, and both are connected. We talked about aircrafts, we could talk about helicopters as well, and same thing, you can give a complex definition of what the helicopter is. So this is a little less complex than for the aircraft, and of course helicopter is connected to the aeronautics category, and it is of course connected within this aeronautics category to the term aircraft. Aircraft being close to the helicopter concept in the framework of aeronautics. And as I said, you simply slide and drop to connect the terms. Now I'd like to stop here on this video, because we will see later on how we can create the connection of one legal system to another. And this brings me to the next video. The context of the EU is a context of 24 languages, and this is precisely the context we tried to reproduce. Each national vocabulary was built based on the same pattern. Now, in each member state, we have one or several national languages. It's the case in Belgium, where we have French, Dutch and German, but we have also foreseen other languages. And this is what we mentioned, by the way, in the previous steering committee meetings. We had said we would present the other languages, but we had first decided to open this possibility later on for the translation purpose. So we had foreseen the possibility of adding languages. We have 24 official languages in the EU, so concretely speaking, we have indeed integrated these languages. Now, theoretically, there is no limitation. We could add as many written languages as we want in each one of the national vocabularies. Concretely, what you have here is once again the abstract of the Belgian thesaurus in French and in Dutch. Each concept has a number. It could be the same than a URI. As you can see, for instance, a concept of additional claim, and the equivalent in Dutch, it's concept 20. Well, this concept 20 can, of course, be translated into all the languages of the world because the organization of legal concepts will remain the same. Concept 20, additional claim, belongs to the category concept, which belongs to the category judicial law, general principles, and it belongs to the top term judicial law. So in fact, the organization of the concepts will always remain the same than in this example, which is specific to Belgian law. In order to make this project available in the 24 official languages of the EU, we decided to use automatic translation and the tools used by the European Commission with regards to automatic translation.
We will soon hear a speaker on this question. The Legivoc project is available in the 24 official languages of the EU. This means that all national legal vocabularies that were delivered are accessible in the 24 official languages. We talked about 81,725 terms earlier on. We have in fact 2 million terms multiplied by 24. That's 2 million terms in a strictly legal context, so it's strictly related to law. So of course this is an argument of quantity, but quantity doesn't mean quality. So there's one element that should be kept in mind, namely these terms are in a strictly legal context.
Thank you very much. I'm Spyros Pilos. I work in the Directorate General for Translation of the European Commission. I will start by saying that by referring again to the 24 languages that were already mentioned, but here is a slide where you can see when they were added. Now, the European Commission has a lot of translators and a lot of people working for translation in the different, also in the European Commission, but in other European Union translation services in the European institutions. So you see that DG Translation, which is on the top right, already has 2,500 staff, out of which 1,700 are translators. However, we needed machine translation, so we developed something on our own, because even to make the website that we have, the europa.eu, fully multilingual, we would need more than 8,000 translators a year. So there are also interactions between the different actors and with the actors in the member states, between different administrations, but also between with the citizens and with businesses. So the Commission has a vision which can be called e-government, let's say, where we try to set up a system which would allow people to ask a question in any language they like and get to an administration that works in another language and get back a reply in their own language. This is the vision. Now, since we are in a legal but also technical meeting, I think it's important to mention the term interoperability, which usually refers to technical interoperability or even legal interoperability, and it's necessary for systems, but also administrations, to be able to talk to each other. The Commission has two big activities, let's say, in this domain. One is the European Interoperability Framework, and the other one is a funding program which is called ISA, Program for the Interoperability Solutions for Public Administrations. I mentioned these two because, first, the European Interoperability Framework has 12 principles, and I highlighted multilingualism, which is considered an essential principle for interoperability. There is the link also to the framework so that you can see the details, but it's important that language is already highlighted as an issue related to technical communication between administrations. We decided for machine translation because it's practically the only viable solution, and as it was mentioned before by Hughes, I mean, you have to start somewhere. You have to have some suggestions. So machine translation is considered a critically important technology for multilingual Europe. Now, what did we do? We have developed, the European Commission developed this project, and it was released in June 2013. It covers all 24 languages. It uses statistical machine translation using a software called Moses, which has been co-funded by the EU. And the development has been funded by the ISA program, and maybe you can understand why this was the case. As machine translation is part of interoperability. This is available in two ways. You can use it through a web interface. Any individual can do this. And it can be connected to a system. In the case of Legivoc, it was not connected to the system. It was, manual requests were submitted, as far as I remember. But there could be a possibility in the future, if there is a future for Legivoc, to connect to the system and ask for suggestions for different terms. These suggestions would come from the translation memories of the European Commission, that is, all documents that have been translated in the past 20 years by all EU institutions. We are talking about, at this stage, around 900 million sentences in 24 languages and with an increase rate of 20% per year. So the user interface, the special features of this this service are that the user interface is available in all languages, that the formatting and format of the documents are maintained. We have specific formats for translation, TMX and XLIF, and some indication of quality and feedback mechanism. I try to focus on what is more relevant for Legivoc. Also, it's secure, but this is relevant for public administrations in the member states who do not want to submit information to the internet. I will refer, at this stage, MTITC is available for the staff of European institutions and bodies, and I list them there, through online services which are funded or supported by the EU. And we have real-life trial and pilot projects with public administrations in the member states. We also have collaboration projects with universities which participate in the scheme we call European... There is denies, something appeared, sorry. Okay. A scheme we call European Masters of Translation, which is a quality label for a number of universities across the EU. Online services connected already to MTITC, which are already in production, include NLEX. In fact, in NLEX you can search as it was presented before, and after you find the results, you can ask for a translation of the results in the language that you want. In test, we have e-Justice, the e-Justice portal, which is almost there. The open online dispute resolution portal, which is also a legal portal for consumer disputes. And there is also the Circa BC, which for those of you coming from public administrations and participating in council working groups like ELO, for example, it may be useful to know that the next version of Circa BC will also offer machine translation, so you will be able to translate the working documents in the language that you prefer, or languages that you prefer. And there are more services in preparation, like the tenders portal of the EU, a portal where open assets are published, like JoinUp, and also other services linking European employment services, etc. Now, for public administrations, we have launched a series of pilot projects, and we have launched a real-life trial in which public administrations can participate on a voluntary basis without any commitment on our side, on the Commission side, but also with some commitment of resources if they want to do certain things on their side. Now, staff members in the public administration can have direct access to the standard service. They just have to ask for it. If an organization wants to participate in a customization project where we can build things using your own data, then we need a bit more formal administrative agreement. These customizations practically include 5 types. which the first one is connecting an information system of a public administration to the MT-ITC service, and the rest include different configurations of developing a system and with own data and making it available either through our service or making it available in the premises of the public administration. Anybody interested can contact us. We have 3 ongoing pilots. One is with the Central Translation Service of Finland and the Prime Minister's Office, the German Armed Forces Translation Service, and Education Administration in Greece. Discussions were held with more public administrations, but we did not have finally pilot projects because they did not need custom engines. I mention this because in the case of Legivoc, what has been used for translation was just the generic engines. Now, if there is a future in such a collaboration, we could consider seeing whether there is a need for something more customized, and this would be possible. In other cases, we had the same problem that you have met, that is, either there were not enough data, or the data were not, could not be shared, or they were in a very bad format, PDF, so they could not be used practically. And we have some special pilots. Legivoc can consider this as a special pilot because it has ministries of justice in the EU, and it's an atypical, let's say, pilot in the sense that we mean in this context. But we have also contacts with networks, the Association des Conseils d'État, the Cour Administrative Supreme, CJUE, and the network of presidents of Supreme Courts. And we are developing new languages as well, a special pilot with the Norwegian government. Anybody in the public administration can just send us an email, get an ECAS, a password, let's say, through an authentication service offered by the Commission, send us an email and we just give access. So it's very simple. I just refer to the EMT universities to say that what we try to do there is to let universities use the service in their teaching and in their research, to examine aspects of use of machine translation for translation, for example, post-editing, machine translation. And what we would like to get back is information about what were the results of this operation, so that we learn and we can improve the system. What next? We're going to move from the machine translation, this service that is run by DGT, to the Connecting Europe Facility Automated Translation Platform. Connecting Europe Facility is in fact a funding program which will run between 2014 and 2020 and will fund digital service infrastructures across Europe. Automated translation is the platform is a building block, a core building block to be reused by other services. E-Justice is one of these services. ODR, the online dispute resolution platform, is one of the services, and there are many more. The emphasis will build, this platform will be built on the existing machine translation service, but will put on emphasis on secure, higher quality and customizable MT, and that's why I mentioned this in relation to Legivoc. In fact, the outline of our system architecture right now includes these 3 parts, these 2 parts. On one side we have the service with the engines running, and on the other side we have the data which are used to build these engines. But we built one type of engines. The difference will be that with the new system, we're going to put in the middle an engines factory. So for each type of customer, we're going to build specific engines using specific data that will be appropriate for their domain. And we will collect from all member states language resources, tools like the ones that were mentioned, vocabularies, glossaries, natural language processing tools will be collected and shared between the different, used by the automated translation platform to develop custom solutions for each of the digital service infrastructures. So from the data, from the language resource, we are going to build the engines in the factory and then deliver them through the service. The objective is to have a secure and performing service to improve the quality that is delivered by the factory and to make it customizable through getting more and better language resources. Just to say about the free real-life trial that there is still time for organizations around the EU to sign agreements and launch pilots until the end of June 2015. We can sign an agreement until then. Any staff member can just ask for access at any time. Access will be free of charge until further notice, and this is because we are going to discuss how this service will be delivered in the future only after the Connecting Europe Facility platform is in place, because public administrations will be ultimately served by this platform. So until then, we do not want to confuse public administration, so it will be free until further notice. But from the lessons we learned from the pilots with member states, we will develop operational support and methods for the Connecting Europe facility. I also have a page where you can have the links to all the information related to our service, to the ISA program and the development of our system, the work program for Connecting Europe facility, all activities that are related to language technologies in the EU, either coming from the Connecting Europe facility or from Horizon 2020, which is the funding program for research and innovation, plus the link to a page maintained, which includes language technology resources like Legivoc, but also DG translation memory and other resources. Thank you.
Merci, Spyros.
Thank you, Spyros. I'd like now to give the floor to Professor Mazet. As I said before, Professor Mazet wrote a thesis on legal vocabulary, so he's following closely the emergence of legal vocabularies as expert, and he knows the qualitative jump we can make by using artificial intelligence to translate the law. But Professor Mazet also says that legal information as a raw data will transform into knowledge when it is used by lawyers or experts. So we could say the intellectual practice of legal translators as well. So I'd like to have your opinion on the automatic or machine translation of the law. Legal multilingualism presents different aspects and different difficulties that can be related to the translation problems and to the issues related to compared law. Indeed, compared law is an information tool that reflects upon the diversity of laws and, of course, the diversity of languages. In one uniform legal language, you will find issues of legal systems diversity. Now, in a linear way, we can understand that so far we've been talking about conceptual descriptors of terms and terminology, but one needs to know that the semantic aspect of translation is not the only one. We also have the syntax aspect. Indeed, legal vocabulary is integrated in the language of one country where it was born. This adds one further layer of difficulty. Indeed, we have there to look at the characteristics of the natural language, because legal jargon, legal language presents different aspects that are added to the natural language, and therefore syntax will disturb the legal language. Let me give you an example. If you want certain rules to apply, or if you look at the different application derivatives, it's one thing. But if you find that in one sentence a rule is not applicable in one situation, we're talking about non-application and not application. So these issues of syntax are of course important and should not be ignored. So far we will limit ourselves to examining the issues and discuss the issue of legal multilingualism on 2 points. There is a problem of legal multilingualism when one single legal order knows different languages. It is the case with EU law. We have the obligation here to obtain texts whose meaning, spirit, and effects are perfectly equivalent in each one of the official languages. Indeed, the objective is to make sure identical rules emerge simultaneously in different languages. This is a first hypothesis. EU law is expressed in different languages. Another phase of legal translation is that of modalities to access other laws. The objective of Legivoc is to compose an instrument giving access to laws in the European Union sphere. But what happens? Sending queries in foreign legal dossiers makes it difficult for a legal expert, because there will be a confrontation of terms that is very much part and parcel of compared law. This is why we need to create tools and instruments that will be capable of managing this comparison. In other words, we must be able to navigate towards relevant information without prejudice to the integrity of the relevant national legal laws. This is on the verge of interpretation and goes well beyond translation. Indeed, there is a tight connection between legal concepts and the language that expresses them. This strict connection between language and the law will make it difficult to translate the law, and will of course mean that sometimes the translator will have to reflect upon the creation. When confronted with legal terms, we can have a morpho-semantical equivalence first. This is the equivalence of a pure literal translation, where, in this case, we have a complete formal and semantic equivalence. I will take the in Italian case of bilancio, the acquisition of the legal personality, same thing. But we need to be very careful, because in a large number of cases the morphological equivalence is not related to the semantic equivalence. It's the case of administrateur and administratore. In Italian law, the term administrator is used for all leaders, whatever the position. In France, we use the term only in limited companies with a board of directors. So we see how perilous this can be when it comes to accessing information. And when we want to take a semantic equivalent with a term that is morphologically similar. The other difficulty is related to the conceptual equivalence expressed with specific descriptors in each language. For instance, the concept of statute is atto constitutivo in Italian, statut. But the translation of atto constitutivo is always possible, but it does not correspond to the same concept in French law. These are not the statutes of a company. So we see the problem with automated translation. This will lead to noise, if I may say, to non-relevant translations in French law, and it will be incorrect or incomplete in the Italian system. Another possibility is a very important point, an important case where we have the legal jargon which is specific to one given legal system and has no equivalent in another legal system. This is the case in, well, collective or class action. We do have class action in some countries, Italy, I think, maybe others, and we could translate, well, collective action by group action, but class action, as we know it in the US law, does not correspond to action de groupe in French law. Action de groupe is only for trade or consumption law, and in US law it applies to all sorts of other legal domains. So we see how difficult it can be. What I'm saying is that the legal equivalence does not take into consideration the crossing of legal systems. This is why it is so important to look for a level of intrinsic relationship existing between two legal orders, beyond the simple legal translation in the classical meaning of the term. This is what we call the functional equivalence. We will look for an operational relationship, and we will try to go beyond the technical level of application of a legal norm to reach the objective that this legal rule or norm pretends to achieve. So this is when we look for the equivalence of the functions of a legal standard in order to obtain an equivalence that will translate similarity, analogy, or even synonymity. The idea is to even attempt at identifying this equivalence in functions. We find it methodologically in the analysis of the functions contained in the texts themselves. Indeed, a number of definitions are real rules to interpret the sentence that allow to interpret the modalities of interpretation and application of a law or rule. So the equivalence obtained between two legal systems will then operate in the following way. Within each legal order, internally, nationally, topics will be structured. Whether we're talking about an institution or a body, we will do so following the method suggested in the different theses we will present it, with connections and relating the different descriptors in different models through information and others, and then we will proceed to interconnecting the structures that were created. This interconnection of structures will operate based on the functional equivalence. Now, this may appear at a general level, but also at a very technical and specific level. The application of this rule has a broader scope than the simple relevance of having access to a foreign legal law and rule. So through the internal navigation of a system, we will show similarities, affinities, differences, divergences. In other words, we will be able to measure their degree of integration. In other words, we will somehow deliver the keys to harmonizing the different legal systems, and this is absolutely fundamental. We see here a real renewal, renovation of the comparative method, because so far practitioners are no longer satisfied with the knowledge of the simple fundamental principles of foreign law. These were the principles of Savigny in the past century. Today, legal experts, practitioners, want to apprehend a legal order in its specificity, technicity, and autonomy. The innovation today is very much the fact of new technologies and IT. Thanks to this new tool, legal experts can look at facts in a foreign legal order. They know how a foreign legal order will react in a case similar to the one at hand in their national legal order. And therefore, this can be easily translated in its total objectivity and concrete aspects. From that point of view on, based on the specific rule that will apply in the case at hand, we can base the operation on the legal concepts, but also, this is fundamental methodologically speaking, based on the implementation of the legal concept, but also the implementation of the semantic fields of the concept. These semantic fields, through the legal concepts, will give order and create order in the conceptual environment. This is particularly interesting because in application of several semantic relationships, such as assumption or inclusion, we can proceed and based on a certain fact, on a certain given concrete fact and case, and we can deduct the legal architecture that commands this fact up to the most abstract level. So indeed, the interpretation of the fact is completely new, and there's a radically new dimension that will be attributed to the facts. If I am, let's take the assumption that I'm a foreign legal expert and I don't know French, I don't know the legal system that prevails in France, and if I take, for instance, the example of pollution by hydrocarbons. Hydrocarbons is a concept that can be translated, but if I ask for the interpretation through the induction, I will find waste as well, because if you add hydrocarbons to salted water and certain minerals, I mean, it creates waste. It is considered as waste in the framework of the directive. I can't remember what the number of this directive is, but this directive says that we are in the presence of waste, and that those responsible for the pollution and for this waste in seawater can be the person that sold the hydrocarbons, or even, why not, the owner of the ship. So we started from a fact, from a factual concept, hydrocarbons, and through the structure, through our navigation in the structure, through the semantic concepts, we've been able to reach the concept of the first owner. We have indeed moved towards the law, the legal concept, simply starting with the fact. So we changed the scale of comparison without any prejudice to the legal system concerned, that is the one where we find the directive, or the national systems that adopted the directive and translated it in their internal law system. So this is how the issue can be described so far. I moved fairly quickly there, but we may be able to see later on what methodologies can be proposed when it comes to comparing laws when queries are sent through the national systems. Thank you. Thank you very much, Mr. Mazet. We could come back to the Legivoc project. Well, to give a brief summary, we've talked about the vocabulary issue, we've talked about the automatic translation issue, and we talked about terminology as well. We were directly inspired by the articles published by Professor Mazet. This is why it was interesting to listen to him. It's based on a content management system. It was developed by the École des Mines in Paris, as we said before. I will show you how these vocabularies were integrated and how they could be used through Legivoc. Earlier on, I presented an entry, article by article, but of course it's a complete file that was inserted, or rather, I'm sorry, concept by concept, says the speaker, and it's a complete file that was inserted in Legivoc. It's a complete national file in the national language, or national languages, but we also integrate the translation thanks to the machine translation tools provided by the European Commission. Now, concretely, when it comes to Legivoc, so far we have 14 national vocabularies integrated. Croatia will be added, Croatian law will be added soon, and we have 24 languages available. All legal vocabularies provided by the European member states will be translated, and these translations are formatted. An example with Belgian law, we have three languages, three official languages in Belgium, French, Dutch and German. You have here the vocabularies in Belgian law and available in English as well. Obligations and sanctions refers to a single concept, which is 1026. It is then translated into all the languages of the EU. We've seen English, we see French, which is one of the official languages of the EU, and we will see Greek later on, which is not an official language in Belgium, while being an official language in the EU. But you see that related concepts are present as well. I will talk about the quality of these translations later on. This is an important concept that will be discussed later. Same thing for Spanish law, available in Spanish. Concepts are presented in Spanish, but starting with Belgian law, so we find the same tree that is reproduced whatever the language. The same is true for German or Germany. We have here a legal vocabulary which is in German labor law. We have certain concepts here. For job centers, this is important because it is available in several languages several times. Why? Because the source vocabulary was provided with translations made by the Germans, but we also applied automatic translation, which means that we end up with several translations of the same term. We have more information, more semantic relations of the same concept. Out of memory, I think this was concept 10,038, and this, of course, relates to the URIs, the single identifiers that will be used in Legivoc. Each concept has one URI. Each concept identified in one single way will be translated in the official languages of the EU.
Deuxième point de ce projet.
There's a second point in this project, and I think that we will stick to these second point because the technical standards have been mentioned before already when mentioning SCOS. The second point is the alignment of national vocabularies. The approach we started on is that nothing beats the human factor to align national vocabularies. So attempting to use a machine translation only to align concepts would lead to major difficulties, and the human approach seemed absolutely essential and less dangerous than translation using a machine. Now, there are two approaches for this human intervention. We can use the work of DG Translation of the Court of Justice of the European Communities, and it might be useful in that matter to look at a modular approach, and we see the different building blocks that have been used to build Legivoc. And I would like now to invite Barbara Dew to take the floor and discuss the practice of the legal terminology in the Court of Justice of the European Union. I suggest we have a break before we discuss these different elements. So we looked at the human approach to well, simply reuse the approach that has been developed already, and we will see this later on. And this is an approach that can be seen in the video we produced. So once again, we use the alignment system in a broader system. This is a test phase of Legivoc. We have a few indexed vocabularies. We have German labor law, so there is no question related to aircraft here or aeronautics, but we have only two concepts. We have aircraft, we have helicopter. The alignment is very simply one file, one chapter that you can click on, and what we did is search using the multilingual concept. The tab can be clicked on, alignment. The aircraft Eurovoc concept can be aligned with the French concept, should it be relevant, based on the activities of the Court of Justice, for instance. The same is true for the related concepts or semantic relations. We have, for instance, the air transport. We have piracy, we have fighter aircraft, combat helicopter, and so on and so forth. This can be found in Eurovoc as well. It's not really the legal vocabulary here. It's rather related to the facts, as were discussed earlier, but these alignments can be introduced. So we can look at the four vocabularies that I presented as examples. So that is German, Danish, Spanish, French. If we add the French concept, we have the concept of helicopter as seen previously in European law, but also in French law as inserted. So all the terms will appear on the screen. We can also add translations, as we've done in English and French, and in Spanish. So much for this part of the presentation. One last point that is of interest for technicians. We talked earlier on about formats and access through Sparkle. I'm not really an expert in these questions, but it is possible to fill out a form and integrate a few code lines to filter information in Legivoc using the different objectives. I hope it's quite visible on the screen. We can filter results of the concepts introduced through languages, but also through the law, because of the law, because of the language, and because of the alignment. This can lead to an XML file that can be used and reused, of course. This is the point and the objective. The human dimension can be seen in two aspects, and I will close the human dimension on this point. First, we can use the work that has been done before. This is, of course, qualitatively speaking, a reference, but we can also refer to other interaction spaces where factual questions are brought up. So we have one space, which is an experimental space, aligning legal concepts between them, automatically, simply using the work that has been done by the different contacts in the network of the Ministries of Justice, and we have representatives of these networks, or former representatives of these network, such as the network for the legislative cooperation between the Ministries of Justice of the EU. How does it work concretely? Well, we have a number of contacts in the networks. A query or request is sent by someone in the member states of the EU. There's one common request sent by one contact, and replies are sent. So what do you do in this situation? What do you do in case of air pollution, for instance? There's an air pollution in a city with several million inhabitants. What do you do? What legal solution do you bring in such a case? We're talking about facts. This is an example. So there's one single question or request sent to the member states, and as many replies as there are member states will be sent back. We have the possibility of adding keywords. So each one of the contacts represented by their flags will select keywords corresponding to their national legal vocabulary, ideally in their national language or in another language. They could also possibly correct translations if, for instance, they express themselves in English and they are in Hungary. One example related to tort law. So this may be a question related to a pollution issue, and the concept of tort law comes up. So the UK representative will raise a question and raise a request or send a request related to tort law, which is a principle in Anglo-Saxon law. France will answer, will give its own answer to the request, and replying to this request, it will associate keywords such as responsabilité délictuelle. In Belgium, the concept of responsabilité quasi-délictuelle will be sent. We have the Spanish concept, responsabilidad extracontractual, that will be sent, etc., etc. So each representative will send keywords. So the pivot is the law and not the language. So it's around common legal concepts that we will have answers or replies. There will be differences in the replies, but we will come closer to an alignment. So using a collaboration tool, taking into consideration the human concept, we will be able to connect legal issues, concept, and realities that can be expressed in the European sphere. This connection of the British concept with the Hungarian, Spanish, Czech, Italian concept, and I hope I did not forget any members of the steering committee, this works independently from the language. So the tort law expressed here in Arabic could be related to the responsabilité délictuelle expressed in Chinese for French law. The links do not change anything. We have the same reality between the concept number 20 in Belgium and the concept 10,038 in German law. So the concepts are related independently from the language. The national dimension is important. If we have 24 languages in the EU, all languages of the world are spoken in the EU. We talk about citizens in the EU, but we should talk about individuals subject to law, because we have people traveling, we have students, we have all sorts of reasons why almost all languages, or in theory all languages of the world, are spoken in the EU. We have Chinese, we have Arabic spoken, etc., etc. The approach of Legivoc was to connect languages and laws, and all official languages of the EU were represented. And we could, of course, extend this project to Arabic, Chinese, Russian, etc. In that regard, we have already undertaken to contact the China Law Society, the Federación Iberoamericana de Asociaciones de Derecho e Informática, and the Ibero-American Federation of Law and IT Associations, the Arab Center of Law, and the Free Access to Law movement via a conference where we presented Legivoc in Jersey. The system is prepared, is created to work with an unlimited number of states and languages. This was confirmed by the developers, very simply because if you take, it's on the Belgian example, if you take one state, there can be all possible languages as an indication and connection. I will stop here, and we will later hear a number of other presentations, and we will have your questions. Thank you.
Right, so let's resume our discussions with a presentation by Barbara CJUE, who will talk about the legal terminology and the work on legal terminology done by the Court of Justice. I asked her to explain what a jurist linguist does within the DG Trad of the Court of Justice. I'm an administrator within the Projects and Terminological Coordination Unit of the Court of Justice. I'd like to present the different projects that we have within our translation department. Now, why legal translation? Well, in order to improve the understanding of the concepts of national law, to allow the jurist linguists to save time, to avoid repeating the work that has been done before, and in order to have a better terminological consistency in our texts. So how do we do that? We conduct terminological research, we create terminology fact sheets, we pre-process them, and we ensure quality treatment as well. Now, who does legal terminology? Who produces legal terminology? Well, the jurists and linguists of the 23 language units. Our unit projects and terminology coordination is there to ensure the quality of the content from a terminological point of view. And of course, the information sheets, terminology sheets, are available to other departments. Indeed, our material is made available to all, and DG Trad has a database. It's a terminology database called Courier Term. We do produce punctual terminology, which means that any jurist, linguist can create a sheet when they are coming across, let's say, a difficulty. Then we also produce specific thematic terminology, and we have a quality assurance project. How does it work? The
jurist-linguist of the language of procedure, which means the start language, will provide explanations on the national concept that may be difficult to construe or delineate in another language. This is contained in the fact sheet, which is then transmitted to all other jurist-linguists responsible for the translation of the text concerned. We also produce thematic terminology. If we have, for instance, applications with very short or very tight translation deadlines, it can be very useful to use thematic terminology. So far we've collected the rules of procedures. It's called JUDIT, and we also have concepts in the framework of compared multilingual legal vocabulary project in family law and the law on foreigners and criminal law as well. We are at the moment developing a number of fiches in criminal law as well, and we're trying to do so in the framework of the project I will describe later on, the connected project. Jurist linguists also use the terminological analysis we have conducted. One pre-processing system allows the translators to look at the multilingual fiche that we have produced. Another type of pre-processing is based on the knowledge of the legal expert and translator of the unit of the language of procedure. This is very interesting because these fiches will present information in a very structured way, in a way that can be accessed to all and at any time, especially when the different documents are translated, when it comes to, for instance, a preliminary ruling procedure, and when there are replies, rejoinders, and so on. And this is a way to ensure legal correspondence. This is an example of a terminological pre-processing based on the VJM collection. We have conducted the analysis of the ruling in C37614 following a request for preliminary ruling sent by Ireland. It contains terminology in family law. We suggest that the translator looks at the fiche proposed in the last column with hyperlinks. We indicate the French term in the first column as found in the judgment. In the second column we have the term as part of curia term, and the third column indicates the original language, English in this case. This third column also allows us not to lose any concepts in the framework of the procedure. In other words, we keep the terms of the original document up until the moment of the judgment. Because, of course, the documents to be translated can be in different languages. In that case, the Irish jurist linguist did give a number of precisions or clarifications of the term contact rights or rights of access, which is droit de visite. These two terms, contact rights and rights of access, were part of the preliminary question, and the question was, are these two terms covering the same concept? On this fiche, you see that rights of access is the terms used in Irish law. It is in the red box. In the general comment on the same fiche, an explanation was given by the Irish legal expert, saying that there is at the moment a recommendation to use contact rights rather than rights of access. It also indicates that the term contact rights is used by doctrine and case law as part or in the meaning of the Hague Convention. This is another rich example in the framework of the Quality Project. We have conducted a pre-treatment, or pre-processing ones, for strafbaar feit in Dutch, in the Dutch system, and Straftat for the German legal system. We always say which legal system is concerned, because there can be different languages and different legal systems. In both cases, the jurilinguists in the original language gave information to better delineate and understand the concept. The description of the concept core that could apply, and this is a human behavior that goes against the law, and that can lead to a sentence. In the German part, we can see that Straftat is used in case C214, and strafbare Handlung is the synonymous used for an equivalent to strafbaar feit in the case mentioned. This is the same part of the fiche in Dutch. In this part we can see that the Dutch term was used in C8812, so it's strafbaar feit that was used, and the Dutch legal expert added delict on the fiche because it is also used in the Dutch legal system. In the general explanation, we see that another explanation by the lawyer linguist was added to avoid confusing the Dutch delict and délit and the French law, délit being a more restrictive concept. If we look at the French part of the same fiche, so we're still talking about similar concepts, but I preferred to have several slides in order to facilitate visualization of the concept. In this part, we see that the concept can be covered by two terms, infraction and infraction pénale. The added value of the work of the lawyer linguist is this general statement that helps other lawyer linguists understand the fact that infraction is a generic term for the most restrictive concept of infringement, contravention or crime, and there's also a connection with the fiche dedicated to each one of these different concepts. If we now have a look at the same fiche in English, we see that there are three synonyms offered, and the use of the different terms can vary according to legal systems. There are several legal systems in English. So based on the French explanation, we see that there's a false correspondence with the French term crime, indeed, or crime. Crime, indeed, does designate the principle of the infringement, whereas crime is one type of criminal offense in the French system. Thank you for your attention.
Merci Barbara. On voit bien là l'énorme travail.
Thank you very much, Barbara. This shows the remarkable work done by the court and the very exhaustive fiches that were produced by the Court of Justice of the European Union. At the same time, we've been trying to incorporate the work done by the court and more. I will rapidly give the floor now to Mr. Mazet because we are running short of time. Mr. Mazet, did you want to comment on that, on the work of the court? Yes, but I think that I will, well, very simply confirm what was said before. I will certainly follow the reasoning followed before, and especially I will agree with the methodology, and I'd like to share with you some reflections that I've had when analysing the different environmental laws and especially in the framework of a course on the internationalization of the law. When talking about instruments that allow us to manage multilingual concepts, I'd like to say some words about the concept of multilingual anthology. This could be defined as a set of terms that can be used to describe objects and connections or relations in certain areas. But an anthology is not limited to a set of terms or words. It should be perceived as a semantic network in the frame of which each term acquires or clarifies its meaning through the connections it has with other terms. If, for instance, I use the concept waste, a certain number of other terms can be connected. Processing, storage, Directive of 3rd of February 92, Article L 541 of the Environmental Law, nuclear waste, Vienna Convention, etc., etc. This is a semantic field that can be ordered following a certain legal reasoning materialized by a set of semantic relationships. So these information will be presented in the format of natural language text in a set of words, international or supranational standards, derived law, national law, case law in the different countries, or international case law as well as arbitration judgments. As I said, this is presented in the format of text in natural language, and the anthology will be elaborated based on this information, these different data. So the terminology of the domain will be used to conceptualize the objects present in that domain in a language presenting the knowledge called a conceptual graph. This conceptual graph will be a tool to model the texts and give a certain mapping of the words in this specific field. So the graph is a set of words and qualified semantic relationships. They can be specific or generic in the order of legal semantics. They can be synonymity relationships, anthology relationships, information relationships, and these relationships testify of the usual practice among lawyers, such as the qualification of facts, analogy, extension, a contrario reflection, etc., etc. So these graphs represent semantic networks destined to structure and organize information within a group of data, and they are the ultra-dense core of legal information contained in the text. The idea is to allow the machine to better exploit different contents, providing a conceptual vocabulary that has been structured and well-defined. The anthology will provide the user with an intellectual ergonomy when the user is at a loss when confronted with the inflation of EU law. The construction of the anthology includes first a linguistic chapter which is dedicated to the definition of terminological resources. The idea is to identify the relevant legal concepts in several languages, in the 24 languages, French, English, and so on. The passage to the foreign language versions will not be translated, will not be limited to a simple translation or literal translation. Indeed, when it comes to the concepts involving, in most cases, access to a functional equivalence, in other words, a concept that is different from a language or linguistic point of view, but that has the same objective, to use a certain methodology. It is imperative. We need the equivalence, the concordance, the proximity to be used. So this relation or relationing will apply to the concept, but also to the semantic field around the concept in order to expand the concept and its related terms. This requires, of course, the action of multilingual lawyers, experts. After that, we need to structure the concepts, and this using relations such as the ones I mentioned, inclusion and so on, in order to define the graph or the semantic fields. This is a way to develop a cognitive relationship, because it is the expertise, the know-how of the lawyer that will command the placement of the different concepts. So he will contribute to creating an order within these different concepts in a European perspective. And from a purely IT perspective, the idea is to develop a language to exploit the knowledge organized in graphs. In other words, it is important to be able to navigate through the graphs using the semantic definitions to reason either through deduction or induction from a concept, exploring its semantic field, and starting, for instance, from waste, we could, come to the prohibition of storage of illegal waste, for instance. So this multilingual interface instrument will have to be built in order to report in the most relevant way of the connections between the different laws examined. The connection between the graphs and especially the connection in the different language versions will allow for a proper correspondence of the legal systems they represent. Therefore, using his own system, the user will be able to access the knowledge within the foreign legal system, and navigating within the graphs and using the interconnection between the graphs, he will be able to identify equivalence or analogy or non-concordance between the legal systems, or lack of correspondence between them. Now, there are two types of access to information. The first one is a simple access to the texts and the doctrine, characterized by a compilation of documents. That is, in fact, the current state of affairs in most legal databases. And even though these systems allow for access to different legal instruments at different levels of relevance, it does not fully satisfy or meet the needs of users who look for a concrete and precise answer in a given and concrete problem. So a system that would not give an exhaustive answer to the problem put by putting in contact the existing text would be problematic. This is particularly important when it comes to compared law. Hence the need to develop systems that make it possible to access knowledge beyond information. In other words, we need access to data, but also to the links and the interdependencies between these data. From a methodological point of view, this is the concept and the design that was adopted to develop anthologies. Reflections and work that are articulated around the definition of the terminology of a certain field. This is environmental law, for instance, or other. When we talk about global law, we have three areas mainly. We have environmental law, because it cannot be regulated nationally, so it is at the very least regional, if not international. We have international trade, because we have the World Trade Organization, and we have human rights as well, that have a universal character, and that are therefore part of an international conception. So to report on the meaning and the significance of a legal text using semantic connections, such as saying concept is or belongs to, is not enough. We need to confirm the relevance of this connection between concepts in a more specific way. So group, class action, action civile publica, or the environmental prejudice, the interesse diffuso, etc., are concepts that have a specific meaning in the legal order. This is why it is essential to take into consideration the existing anthologies and graphs, and we need to take into consideration the description of these concepts. The inclusion will testify of the process, and the qualification will determine the factual element in the text. So radioactive waste will be included from Article 542 of environmental law. On the other hand, the taxonomic hyponymy will allow to classify in given categories. For instance, well, toxic waste will include a certain number of them. There are other semantic connections. For instance, a factual value given to a text, 15 days to define a reasonable time limit. This is a concept in Anglo-Saxon law. But if a legal decision considers that 15 days is a reasonable time limit, it is a qualified fact. Also, the quotation of parts of texts or the incorporation of a legal definition are also part of the action. And this is why it is so important to work with lawyers, experts, even lawyer linguists and connecticians in certain cases. This will be used to order a given legal field, or to create tools that will be useful for consulting texts, or as an instrument to index the texts. In a more evolutive perspective, this mode of treatment of legal vocabulary could be imagined applying what has been developed with web semantic. Indeed, based on the HTML and RDF functionalities, the semantic web will use the descriptive cognitive techniques, and despite the fact that the law presents formal characteristics that are different according to the source, the domain or field covered can lead to a modeling of legal data, and this can be directly understood by the machines. This requires a definition of the concepts and the terms and a representation in XML language of the concepts stored in XDF. But a deeper knowledge of these legal terms shows that formalizing is possible according to the source, the matter, and the object of the text. Indeed, the norms are characterized by a certain degree of formal content. The texts contain the same elements without variation, and there are all contributing to one unity: chapters, sections, paragraphs, etc. So the method recommended would be one to translate the structural characteristics of legal texts in order to convert them into XML tags, and all the tags present in one document could then allow us to classify this in a written category in the format of XDF, and then this would lead to a definition sequence in RDF, which would help us well, simply list the text, classify the text that has its attributes in XML. Once the information has been obtained, with the tags and definitions, we could relate the information. This new methodology would then benefit from the addition of anthologies drafted in a first stage. Indeed, the structuring of descriptors in anthologies in upstream and downstream inclusion, analogies, and information would then be used as tags and XML tags using the bottom-up hierarchical method. This is a proposal of methodology, and this proposed methodology should normally allow to connect and certainly not work on the expression of the concept, but rather on the concepts themselves and certainly on the semantic field that surrounds these legal concepts. Thank you.
Thank you very much indeed to our speakers. What we've understood from all this is indeed the complexity of this question, because of the different languages. Thank you very much to Montserrat Biederman for following this conference on Twitter. I would also like to have time to answer her questions. But so far, all the exchanges took place in English, and Montserrat was surprised to see that there was French, Dutch, German as well. You expressed yourself in French. There was translation in English. What we've spoken about so far was quite complex, and I answered on this question of complexity. I'll come back to Legivoc because the point of the project was to try and make this exchange of information possible, or at least easier. There are 3 sections in the project. First, in search of legal vocabularies. Second, aligning national vocabularies in a multilingual environment. And the way Legivoc is organized is different from what we presented in the second steering committee meeting. First, we have the system as it was presented on the different slides. It's legivoc.org. This is the web service of Legivoc.
This web service will be available for other uses, for instance, the legislative networks of the Ministries of Justice, but also other users. And there's one point which is of particular interest for the Steering Committee, namely that we used two providers of services to finalize Legivoc. The first one will make the use of Legivoc possible within the network for legislative cooperation between the Ministries of Justice of the EU. This is based on DOMPAL, which is a content management system. It's one that you can find in a number of information systems, including, for instance, the French Prime Minister's system, the White House website as well. It's a content management system that is quite useful and quite practical also when you have different languages. This tool is made available using the content management system, and it will be used in other areas that use the same content management system. LEWIS, the Legivoc Web Information Service, will be accessible to by all websites that want to use it. So a call will be made possible on legivoc.org. So it will be possible to retrieve information from legivoc.org. The idea being to retrieve information to create connections. So to allow for this alignment precisely, the developer will also be entrusted with the development of a generic content management system. As I said at the beginning of my presentation, we have a dozen national vocabularies missing. We will simply offer the possibility to all states that wish to do so to upload their vocabularies, and we have chosen Tematres to do so. We've discussed it before because it's the easiest to implement. Now, it was extremely difficult, I have to say, to process so many formats and vocabularies. So Tematres is simple, it is flexible, so we wanted to use it to integrate it afterwards in Legivoc. In this case, we could have, for instance, Bulgarian vocabulary that could be accessible in this space, and we could also have another thesaurus in German. Another example, which is broader, is the legal thesaurus of Algerian law, and we're going beyond the EU, but it's in the framework of a program which is financed or funded by the EU. So there is a link. So Tematres will be used, and following the willingness of the Algerian authorities, this thesaurus will be integrated in Legivoc. There's a second new development. It's legivoc.eu, so the domain name .eu. This is the address you can use at the moment. You will have a viewer that will view the generated SCOS files to make them available, at least for those vocabularies where we have an authorization to publish. For some vocabularies, we had to sign a user's charter, and other vocabularies are open vocabularies. They're publicly available. Some are shared publicly on the web, and others will have to be covered by a user's charter. Others are available on the web. This is the case for the Slovenian vocabulary, and a simple line referring to that vocabulary can be used. When we talk about visualizing or visualizations, we can visualize translations. This is civil law as it appears in Eurovoc. This is European civil law, translated in French and English. But we also have alignments. Alignments will be available probably at a later stage. There was another question regarding the free free usage of these alignments. Of course, it is absolutely free. And there is absolutely no problem there. The only thing is that when there are interactions in the networks for legislative cooperation, there will be a difference, and for other systems, it will be the choice of users. So it could be integrated in other content user systems. The more we have human interaction, the better the alignments will be between the national legal concepts. I hope I did not forget too many questions, but I think that the time has come now to close this meeting. So I'd like to give the floor back to Delphine Agoguet, and I'd like to thank all the participants. I'd like to repeat one thing regarding the Legivoc project, and you mentioned that, Hugues, in the article you wrote with your colleagues. This is a system that aims at ensuring cooperation between active lawyers. So it's very much a project that will help pool the common language of the law, promoting an interaction of the human factor and the material, the machine factor, to ensure the interoperability of languages. I hope that this project has a very long life, and I'd like to thank everybody, and I suggest, well, that we applaud each other at the end of this conference. Thank you very much.